idea of heads of term is that they are created by the landlord in negotiation with the tenant via their respective agents or direct between the clients. And the idea of heads of term is that the landlord then provides the heads of term to its lawyers, and the tenant gives a copy of the heads of term to its lawyers, and the landlord will then draft the lease, or the lawyers will draft the lease in accordance with those model heads of term. That means that the tenant's lawyers should get a lease that mirrors all that's been agreed in the heads of term. Now, as you can see, heads of term can improve the negotiation process. If you're a tenant and I'm a landlord and we have a meeting about my letting you a particular unit, I might come along to the meeting with the RICS model heads of term and we'll go through them. So we might agree that there is to be a rent review provision after 3 years, but that the rent review provision will be upward or downward, not simply always increasing. Or we might agree that instead of having a traditional rent review clause, we'll have a clause that says the rent increases by 10% on the 15th of September 2025 or something of that nature. We might have within our heads of term an agreement as to what's being let. So I might be letting you the entirety of the ground floor of the unit on the right. I might describe it and I might have a lease plan. That lease or that property may be registered at the land registry with a title number. I might refer to the title number, might refer to the title plan when I'm describing the property within the lease and identifying the property by way of a plan. So the theory is that heads of term improve the negotiation process. They mean that parties can concentrate their minds on the key issues, repairing obligations, for example. It might be agreed in heads of term that the tenant will keep this property in good repair, or it might refer to the tenant keeping the property in good repair and condition, or might state that the tenant will put the property in repair and then keep it in good repair and condition. All of these terms have different meanings. Keeping in repair, you maintain what you've got. Putting in repair, if there's any disrepair, if there are any problems with the building, the tenant is committing to putting them right. Reference to repair is different to repair and condition. There could be items that relate to the condition of the building that are not disrepair. The example that I always give people is condensation within double glazing units. Just because there's condensation within the double glazing unit does not mean the double glazing unit is defective, but does mean that the double glazing unit is not in condition. And therefore, where the lease requires the tenant to keep the property in repair and condition, there'd be an obligation to attend to the condensation in the double glazed units. What's our role with regard to heads of term? It's to suggest to the clients that they use heads of term and to have a look at what's agreed between the clients before, either as a tenant, we are willing to accept a draft lease from the landlord solicitors, or before the landlord solicitors are prepared to draft the lease. I do think that with regard to heads of term, before they are finalised, we should always have a look at them, whether we're acting for the landlord or the tenant. We should look at the heads of term to make sure they make sense, to make sure that we're going to be capable of complying with them, and to ascertain what sort of time frame is going to be required for the heads of term to be produced and what sort of time frame is likely for the lease to be completed.